Good evening, everyone. Welcome to Jnanavartini. It has been quite some time since we discussed data privacy law. The last time we discussed was PIPL China. Today, Adepu sir has volunteered to discuss the Connecticut Data Privacy and Online Monitoring Act. He doesn't need an introduction in this group. He's a very senior and active member of FDPPI. Still, I would take 2 lines to introduce him. He is client manager at BSI Group India Private Limited. He has extensive experience in the banking industry, having worked in Canara Bank, Global Trust Bank, Oriental Bank of Commerce, and ICICI Bank, specializing in IT operations, banking application development, and data center management. He's also an ISMS auditor with a specialization in ISO 27001, SOX, and PCI DSS. Over to you, sir.
Thank you, Ms. Manju. Good evening, everyone. At the outset, let me, before I start this conversation, I am not a legal person, as Ms. Manju introduced me. I am a banking technology and technology person. But why I choose this particular topic is that when I first traveled to US, I first landed in the Connecticut state, where my daughter was studying at that time in 2014. So when this law was passed by Connecticut General Assembly, I found, okay, let me make an attempt to understand what is this law of a particular state in the United States of America. That is one thing. And this law, I am not going to interpret anything because I am not a legal background person. So as it is from the text of the law, I put the important and interesting points to share with our community. So with this, I start the presentation. This is a law signed by Governor of the Connecticut State on the May 10th of this year, and it is going to affect from 1st of July next year onwards. This law also mentioned other related laws of the United States. These are the some of laws: Children's Online Privacy Protection Act of 1998, HIPAA, Federal Trade Commission pronouncements from time to time, Healthcare and Quality Improvement Act of 1986, Patient Safety and Quality Improvement Act, Fair Credit Reporting Act, Drivers Privacy Protection Act of 1994, Family Education Rights and Privacy Act, Farm Trade Act, the Airline Deregulation Act. Most of the acts are all these acts, wherever the personal data is going to affect, this law is also referring the particular context. Here, when I was studying this text, I found certain important definitions where we need to have a look at and understand why the definitions and their exemptions were given. So that's why I chosen certain definitions given the section, first section number 1. And I put the exemptions and to understand for our community. So biometric data, we know the definition, but biometric data does not include a digital or physical photograph. One minute. Biometric data does not include a digital or a physical photograph, an audio or a video recording, or any data generated from a digital or physical photograph or an audio video recording, unless such data is generated to identify a specific individual. So sometime back we have a discussion, Navisa initiated one discussion point about the audio video recording. Is it a biometric or is it going to reveal any personal identity of the person who is in the video or audio? So here, this particular law specifically exclude audio video recording. So this is another point when we need to discuss our biometric data definitions in the context of Indian laws, Indian upcoming law, whatever it is. Second, consent. Consent does not include, normal definition we all know, acceptance of a general or broad terms of use or similar documents that contain descriptions of personal data processing along with other unrelated information. If any consent document which is going to acquired by the controller from the consumer, if that has any unrelated information, that will not be considered as a proper consent. Hovering over or muting, pausing or closing a given piece of content also not considered as a proper consent. Agreement obtained through the use of dark patterns. This is a very important word. Dark patterns also defined in this law. So conceptually, we are all not ever considered this. What is the dark patterns when we are discussing in all our earlier deliberations? So the definition will come to know. Consumer. Consumer does not include an individual acting in a commercial or employment context or as an employee, owner, director, officer, or contractor of the company, is a partnership a partner or sole proprietor of non-profit or government agency. All connections as employee or a service person of an organization is not defined as a consumer, whose communications or transactions with the controller occur solely within the context of the individual's role with the company. Dark patterns means a user interface designed or manipulated with the substantial effect of subverting or impairing the use of autonomy, decision-making, or choice of the consumer. That also include, but not limited to, any practice the Federal Trade Commission of USA, which defined as a dark pattern. Federal Trade Commission has already a regulator in USA, which is like our SEBI sort. They already defined last dark patterns in this context. So any way, if a person trying to get a consent by using any of the dark patterns, it is not considered as a proper consent. This is already we are aware. Decisions that produce legal or similar significant effects concerning to the consumer is defined as means decisions made by a controller that result in a provision or denial by the controllers of a financial or lending services, housing services, insurance, education enrollment or opportunity, criminal justice, employment opportunity, healthcare services, or access to essential goods and services. In case the controller denies a particular providing a service by some means, that will not going to produce a legal or legally significant effect on the consumer, so that the consumer can go for a legal redressal. Personal data explicitly excluded. In this particular law, the personal data explicitly excludes any de-identified data or publicly available information. Further, it also defines what is publicly available information means. Information that is legal, lawfully made available through government records or widely distributed media, and a controller has a reasonable basis to believe a consumer has lawfully made available the information to a general public. This is normal, the way what we understand public level information in any country. Sensitive data that include all these things, but personal data collected from a known child means if any controller or any organization collecting a data from a child defined a person of the age, as per the definition of child age, that is treated as a sensitive data. That all depends upon the age definition of the person. And one important and significant thing is geolocation data is treated as a sensitive data in this particular law. Sale of personal data does not include what type of data sharing, does not include sale, is that the disclosure of personal data to a processor, which is bound by mutual agreement, the disclosure of personal data to a third party for the purpose of providing a product or a service requested by the consumer, the disclosure of or transfer of personal data to an affiliate of the controller. There, this particular thing is what type of affiliate and what is the relation between the controller and the affiliate need to be verified when they share, or is going to give any implications by use of the data by the affiliate has to be considered. The disclosure of personal data where the consumer directs the controller to disclose the personal data or intentionally uses the controller to interact with the third party. The disclosure of personal data that consumer intentionally made available to the general public via channels of mass media and did not restrict to specific audience, or the disclosure or transfer of personal data to third party as an asset that is a part of a merger acquisition, bankruptcy or other transactions, or proposed merger acquisition or bankruptcy or other transaction in which the third party assumes control of the all or part of the controller's assets. These are all we already aware. So in all these cases, any transfer of the data are not considered as a sale. Targeted advertisement does not include advertisements based on the activities within the controller's own internet website or online applications. For example, when we are browsing a commercial site like Shopper Stop, and we are going through a particular product or a service from the company, when we from that particular website or the company site, we may get the advertisements. So that is called not a targeted advertisement, because as a consumer, the person going to interact with the website showing some interest of where what he wanted. So when he go through the site, he may not get all the information. That's why the company may have the right to, which will be interest to the particular consumer. And second one is advertisement based on the context of the consumer's current search queries, visit to an internet website or online application. So whatever the consumer is looking for, if that is a sort of information is passing through advertisements, it is not called as a targeted advertisement. Advertisement directed to consumer in response to a consumer's request for information or feedback, or processing personal data solely to measure the or report advertising frequency, or performance, or reach of the advertisement. These cases are not treated as a targeted advertisement by way of this law. So these are some interesting definitions given in the law section 1. And let us go through other sections. Section 2 says applicability. This law applies to the entities that conduct business or in the Connecticut or produce products and services targeted to the Connecticut residents, and that during the preceding calendar year, if they have 1 lakh consumers data processing happens by that particular controller, excluding the personal data controlled or processed solely for the purpose of completing payment transactions. This is very interesting. See, now all the consumers, they make payments online. So when we do online payment, we have a lot of personal data in that particular transactions. By excluding these payment transactions from the scope of applicability, I don't know what this law going to protect, how far the consumer rights are going to be protected by exempting the payment transaction data by the various controllers. Controlled or processes the personal data of at least 25,000 consumers and deriving over 25% of their gross revenue from the sale of personal data. Here also I have a bit concern. If a company can sell the data and arrive at least 20% of the revenue, that does not come onto the purview of this law. So 25,000 consumers data is a very minimum. Any small entity in the Connecticut definitely going to have processing the 25,000 consumers data, but the 20% gross revenue from the sale, they may intentionally keep the their sale revenue below 25% and exempt from this law. Section 3, exemptions. The law also exempt certain type of entities and data from the requirements. These following 6 are the very significant exemptions. State and local governments. All state and local government agencies are exempted. All non-profit organizations of the state have been exempted. Higher education institutions, National Security Association registered under the Security Exchange Act of 1934, they are exempted. Financial institutions and the data subjects to who are applicable to Graham-Leach-Braley Act of USA, they are exempted. Covered entities and business associates of the HIPAA are exempted. Then finally, I don't know in Connecticut what are the entities fall under this law is a matter of to be verified by the local environments. Further that these are the institutions from the certain data of these categories also been exempted. They are HIPAA data. If a information of the related to HIPAA, they are exempted. Fair Credit Reporting Act data exempted. Drivers Privacy Protection Act, Family Education Rights and Privacy Act, the Farm Credit Act, Airline Deregulation Act, specific employee and job applicant data also exempted. So where is when this law giving so many exemptions? I don't know how effectively this law going to be implemented in protecting the personal data of the citizens of the Connecticut is to be very looked into future. Now the section 4 talks about the consumer rights as a citizens or the people. What is their right? All these are very common. Right to access, right to correct, right to delete, right to data portability, right to opt out. These are the rights already given in many of the laws, as we are all know. A consumer may access a right to under this section by a secure and reliable means established by the controller. So this law specifies the controller that they need to establish a secure and reliable means to exercise these rights by a consumer. It is a responsible controller. A consumer may designate an authorized agent. This also we saw in our Indian context. Further, section 45 provides certain provisions. A controller shall respond to the consumers without undue delay, but not later than 45 days after receipt of a request for any rights exercise. 45 days is the limit. The controller may extend that response period by another 45 days by giving a reason. If the controller declines to take action regarding the consumer's request, the controller shall inform the consumer without undue delay, but not later than 45 days after receipt of the request. In case the controller decides to reject the request, so it should respond to the consumer within 45 days. Providing information free of charge once per consumer during any 12 months period. This is an option given to the controller. If a controller is unable to authenticate a request to exercise any of the rights, the controller shall not be required to comply with the request. It should come to proper authentication, proper ground should be there for the controller to reject the request from the consumer. A controller may deny an opt-out request if the controller has a good faith, a reasonable and documented belief that such a request is a fraudulent request. If the controller feels that a request scheme is fraudulently, he has a right to decline that request to fulfill as a consumer right. In case of PII collected from a source other than the consumer shall be deemed in compliance with the consumer's request. In case the controller collect any PII from a third party other than the direct consumer who is the subject matter, that data also treated as if it is collected from the consumer. A controller shall establish a process for a consumer to appeal the controller's refusal to take action on a request. This is what we call as a grievance redressal mechanism. So it is a responsible controller to establish a grievance redressal mechanism as per this law. Appeal mechanism should be similar to the process of submitting the request. So the appeal mechanism should not be difficult. It should be as easy as when a consumer is able to submit a request for the access right. The same way, the grievance redressal also should be so easy and easily approachable and applicable to the consumer. Not later than 60 days after receipt of appeal, a controller shall inform the consumer in writing why and why not is doing it, the request fulfillment. The appeal is denied. the controller shall also provide the consumer with the online mechanism, if available, or other methods through which the consumer may contact the Attorney General to submit a complaint. So there are two ways. One is controller has to redress or attend the request from the consumer. Second, controller has to establish a redressal mechanism. After these two stages, the controller's responsibility also lies that he should enable the consumer to appeal to the Attorney General about his complaint, whatever it is. So controllers have a more responsibility to attend the consumer's request to exercise their rights under this law. Okay. Now, section 5, a consumer may designate another person to serve as the consumer's authorized agent and act on consumer's behalf. This already we are aware, as if we also discussing our Indian law context. The consumer may designate such authorized agent by way of, among other things, a technology platform, including but not limited to an internet link or a browser settings, browser extension, or global device settings. So technologically, a consumer can appoint an agent to work on his behalf or exercise rights on his behalf. A controller shall comply with an opt-out request received from an authorized agent if the controller is able to verify with commercially reasonable efforts. So again, controller, if we get a request from the authorized agent of the consumer, why this is coming? Just a minute, please. So agent's request also, the controller has to verify commercially viable reasonable effect, and the request is found to be authenticated request from the agent. The controller responsibility is to fulfill the request. The privacy principles, which are universally we know, all those privacy principles also been incorporated in this law under section 6. Limit to collect the data of the personal data, processing limitation, establish and implement and maintain reasonable administrative, technical, and physical data security practices. No process sensitive data without the specific consent. No processing of personal data in violation of the law of the land. Provide an effective mechanism for a consumer to revoke the consumer consent. Not process the personal data of a consumer for purposes of target advertisement without the specific consent from the consumer. Not to sell the consumer personal data without the consumer's consent. All these are the privacy principles, what we are all can see in almost all the laws of the privacy. A controller shall provide consumer with reasonable, accessible, clear, and meaningful privacy notice. The section 6 clearly mentioned what type of privacy notice to be available to the people from the controllers. A controller shall establish and shall describe in a privacy notice one or more secure or reliable means for consumers to submit a request to exercise their consumer rights. So the notice should specify what type of ways available for consumers to reach out to the controller in case of they want to exercise the right. Controller shall provide a clear and conspicuous link on the controller's internet website to an internet web page that enables a consumer or his agent to opt out of the targeted advertisement or sale of the consumer personal data not later than January 1st, 2025. Because this law is going to come effect from the next year, May, 23 May. So this is a specific time frame given to establish suitable means for the consumers to reach out to the controllers in case of they need to exercise or communicate anything to the controllers. And here this law also talks about what type of technical platform the consumers should get availability or the controllers to establish. Such a technical platform, whatever the controller going to establish, it should not be not unfairly disadvantaged to another controller. Because the portability is acceptable under this law, whatever the platform or the technical means a controller going to provide should not be in a unfair disadvantage to another competitor or the controller. Not make use of default settings, but rather require the consumer to make an affirmative, freely given, and unambiguous choice. So the platform should be able to provide a very fair means for the consumer and be consumer friendly and easy to use by the average consumers. Be as consistent as possible with any other similar platforms, technology, or mechanism required by any federal or state law or the regulations of the land. Enable the controller to accurately determine whether the consumer is a resident of the state or whether the consumer has made a legitimate request. So the platform should be in a position to help the controller to determine the existence of the consumer. Is it properly located came as a legitimate request or a fake request? Now, Section 7 talks about the processorship obligations under this law. A processor shall adhere to the instructions of the controller like any other country and shall assist the controller in meeting the controller's obligations to meet the law. Implement appropriate technical and organizational measures. It's the same way the processor also need to follow all the controls required to be applied by the controller. Shall assist the controller in meeting the control's obligations. Enable the controller to conduct and document for data protection assessments. So controllers are bound to conduct a DPA. So processor has to help the controller in conducting the DPAs whenever required. A contract between a controller and a processor shall govern the processor's data processing procedures. If a processor begins alone or jointly with others, determining the purposes and means of the processing of the personal data, the processor is a controller with respect to such processing and may be subjected to enforcement of the action under Section 11 of this Act. Section 11 talks about in case a processor becomes a controller, in some cases, what the actions the processor has to fulfill. Now for the DPA, this Section 8 talks about how a DPA to be conducted, what is its requirement. DPA to be conducted for processing activities that presents a heightened risk of harm to a consumer. But unfortunately, this harm level was not defined in this law. And the definition, we do not, what is the risk of a harm has been not been defined. DPA required for a processing involvement for the purpose of targeted advertisement. In case the controller want to save the personal data for the purpose of profiling, where such profiling present a reasonably foreseeable risk to the consumer's data, the processing of sensitive data. In all the 4 cases, a controller or processor, they need to conduct a DPA. The controller shall make the data protection assessment available to the Attorney General. Here we have seen in our law, the DPA has to be provided to our data controller, data protection authority in India. The similar way, this law also talks about controller has to make available the DPA, whatever he has undertaken, to the Attorney General of the state. Data protection assessments shall be confidential and shall be exempt for disclosure under the Federal Freedom of the Information Act. So as per the Freedom of Information Act of the USA, the controller not bound to disclose the DPA to the consumers unless consumer get a direction from the Attorney General. So the DPA part will not available to general consumers in general. Data protection assessment requirement shall be applied to processing also. Data protection assessment requirement shall be applied to processing that will be created or generated after the 1st July 23. So whatever the processing happens before this date, that DPA requirement is not there because the law going to come effect from 1st of July 23 onwards only, but not to respective effect. Section 9, treatment of the data. Treatment of de-identified data, how a controller or a processor has to treat the de-identified data has been listed in the section 9 elaborately. So that I'm not going into very details on that. Treatment of pseudonymous data. Consumer shall not apply to pseudonymized data in cases where the controller is able to demonstrate that any information necessary to identify the consumer is kept separately and is subjected to effective technical organic control that prevent the controller from accessing such information. The de-identified or anonymous data, pseudonymized data, the required key or the technology controls are kept separately. Such de-identified or the pseudonymous data, it will not be treated as a privacy data. Consumer rights shall not apply. So consumer cannot claim his rights with respect to pseudonymous data when the controller is able to demonstrate that the key or the technology controls has been separately kept it and has been under preventive. All the controls have been there. Now the exemption C, section 10 says, comply with the federal, state, and municipal ordinances or regulations. If any personality of parties comes under this federal law or state laws or municipal laws or regulations, that is been exempted. Comply with the civil, criminal, and regulatory inquiries, investigations, subpoenas, summons by federal, state, or municipal or other government authorities. Cooperate with the law enforcement agencies. These are all the requirements for the processors and the controllers. Investigate, establish, exercise, prepare for or defend legal claims. There are 8 more such exemptions listed in this section. Nothing in section 1 to 11, including all this section, all the contents of this act shall be construed to prevent a controller or a processor from providing personal data concerning to consumer to a person covered by the evidentiary privileges under the law of the state as part of the privileged communications. I don't know what is this law in the USA. Evidentiary privileges law. That I'm not aware, to see further in case of requirement. And section 11 talks about the regulation part from the authorities. Attorney General shall have the exclusive authority to enforce their violations. In case there are any violation, only Attorney General can take any action. Beginning on July 1st, 23, that is next year, and ending on the December 31st, 24, the Attorney General shall issue a notice of violation to the controllers. See, for this during this period, if there's any violation of this law, the Attorney General only issue a notice. He will not take any action. Not later than February 1st, 24. The Attorney General submit a report to the General Assembly Committee who has formulated this law about the violations happened during that period. Beginning on January 1st, 2025, the Attorney General may, in determining the whether to grant a controller or a processor the opportunity to cure an illegal violation, alleged violations. From 1st January 25 onwards, the Attorney General is empowered to determine whether grant a controller or a processor an opportunity to cure. Means he will not implement the penalties or the punishments, but he may have a as a determination of the Attorney General, he has the right to give a chance, opportunity to cure the alleged violation if it is there. A violation of the act shall constitute an unfair trade practice for the purpose of section 42-110B of the gender statutes and shall be enforced solely by the Attorney General. So this, I think, gender statutes like our CPC in our India, there is a general law under that particular section. The violations are of the act shall be constituted as unfair trade practices. This is also a bit unaware to me. Now, final section is section 12. Not later than September 1st, 2022, convene a task force to study. So this General Assembly of the Connecticut has put this section specifically to study and understand the provision of this law in the next 1 year period till it comes into force. What the task force to mandate is information sharing among the healthcare providers and social care providers. So they are tasked to study, because of this law, what is going to be effect on the information sharing among the healthcare professionals providers and social care providers in the state of Connecticut. Algorithmic decision making. The technology what we are going to implement it in that, what are the algorithmic decision making provisions are there, that's effect on this law has to be studied by this task force. Possible legislation that would require an operator with regard to the children's data, whether this particular law having to have any effect on the children's data, and that may need further legislation that is to be studied. Any means available to verify the age of a child who creates a social media account. So this task force also need to study the children's activities on the social media. Issues concern the data co-locations. That is the data where is locating. If the Connecticut citizen data is out of state, what is the state law within the United States? That is to be studied. Possible legislation that would expand the provisions of the section 1 to 11 further. So this law under section 12 says the task force also need to study whether this law can be amended further or is possible separate legislation to be enforced or brought into the General Assembly. So no later than 1st January 23, the task force shall submit the report. So they given a 4 months time, September, October, November, December, 4 months time to the task force to study these 6 aspects and submit a report to the General Assembly committee who formulated this law. So these are the basic things I called out from the document available from the Connecticut Assembly online. Now this is a link where in Congress, some of the congressmen has introduced a federal law for the data protection. So this is yet to be studied. This is only bill, is not making law. I don't know when the US Congress will pass this law, then it becomes applied. And I also have one more confusion. When the Congress is going to pass a federal law, which is going to be applicable for a whole country of all the 50 states, why each and every state has to pass a local state law for the data protection or privacy protection? I request some of the members in the group, in the meeting, they can throw some light on these aspects. Particularly the exemption part is very much concerned to me, and we can have a discussion on this. With this, I thank you everyone for your time. I'm stopping sharing.